It's certainly concerning when a government limits absolute rights without a principle in justice. It raises important questions about the balance between individual freedoms and governmental power, and highlights the need for accountability and transparency it equates to individual corruption. If I see it as corruption, if I see a limitation placed on an absolute right as being a corruption, then I look to the individuals who do it as being corrupted. They don't respect law, that they're arbitrary with their law. Taking legal action through a court of law is a strong way to hold individuals accountable, especially when rights enshrined in documents like the ICCPR are at stake. Legal recourse can provide a formal avenue to challenge actions that violate fundamental rights. It's crucial to seek justice and uphold the rule of law through these means. Public exposure can add significant pressure and scrutiny, making it harder for any unjust decisions to be made without accountability. It can ensure the process remains fair and transparent. So, the judiciary, right, is supposed to be an independent body from the legislative and the executive powers of the government. That's the way it's set up in law, but a lot of times it's not independent. It's actually making judgments on behalf of the government to keep the system and to keep the pro quo, so to speak. The judiciary is meant to act as a check on the legislative and executive branches, but when it aligns with them to preserve the status quo, it undermines its independence and the rule of law. When those at the top fail to uphold justice, it trickles down through the system, affecting everyone below. Addressing these top-level failures is often the only way to fix the systemic issues. The corruption is a deep-rooted issue that often stems from those at the top failing to uphold accountability and justice. Addressing it requires a strategic approach, like exposing patterns of misconduct and presenting clear evidence. If a judge engages in corruption or breaches fundamental principles of justice, laying an information under the criminal code is a valid legal recourse. It bypasses internal mechanisms that might lack teeth and holds the individual accountable to criminal standards. It's a strong and strategic approach, especially when evidence of willful misconduct is clear. A judge is held to the standard of understanding what an absolute right is. They are expected to be well versed in the law, including fundamental principles like absolute rights, natural rights, and statutory rights. If they fail to uphold or recognize these principles, it can be considered a serious breach of their duty. R.V. Peel, Regional Police Service, Chief of Police. The courts, too, must conform to the rule of law. The rule of law is the very foundation of the Charter. It stands to reason, then, that the courts are duty-bound to apply the Charter. R.V. Wagner, 2015, ONCJ 66. The rule of law. The rule of law not only finds itself in the preamble to the Charter of Rights, its spirit is manifested throughout the document. The idea that there are certain fundamental unwritten principles that govern all members of society, including legislators, and which judges are expected to enforce, is not particularly new. The contemporary concept of unwritten constitutional principles can be seen as a modern reincarnation of the ancient doctrines of natural law. Natural law, a physical law of nature, a philosophical system of legal and moral principles purportedly deriving from a universalized conception of human nature or divine justice, rather than from legislative or judicial action. Natural right, a right that is conceived as part of natural law, and that is therefore thought to exist independently of rights created by government or society, such as the right to life, liberty, and property. Inalienable right, a right that cannot be transferred or surrendered, a natural right such as the right to own property. Absolute right. 1. A right that belongs to every human being. Thompson Newspapers, Lutet v. Canada. While individuals, as a rule, have full legal capacity by the operation of law alone, artificial persons are creatures of the state and enjoy civil rights and powers only upon the approval of statutory authorities. The individual may stand upon his constitutional rights. He owes no duty to the state, since he receives nothing therefrom beyond the protection of his life and property. His rights are such as existed by the law of the land long antecedent to the organization of the state. He owes nothing to the public so long as he does not trespass upon their rights. R.V. Wagner, The Rule of Law. This rich intellectual tradition of natural law seeks to give the law minimum moral content. It rests on the proposition that there is a distinction between rules and the law. Rules and rule systems can be good, but they can also be evil. Something more than the very existence of rules, it is argued, is required for them to demand respect. Finally, at the developing fringes of the new natural law, which goes by the name human rights, are other assertions. Thus, as important as these principles may be, and as essential as it may be, that in difficult cases the judge must stand against the winds and rains to uphold them. Those unwritten principles tend to be largely replicated in the text of the Constitution, with S7 of Canada's Charter of Rights striking me as a prime example. Our written Constitution reflects many, many influences, including the drafter's awareness of natural law. I agree with her that the rule of law is, quite apart from the terms of any written constitution, part of the constitutional DNA of this country, and that its precepts must be abided by and must be applied by judges, no matter how strong may be the prevailing winds or how challenging the social or political environment in which an issue arises.